Hi everybody, it's Andy. I hope you're having a great day. In the video that you're about to see, I'm going to go over some aspects of California employment law with you. Employment law in California can, on occasion, I think, be a bit confusing, largely because there are a lot of exceptions that might apply in your case versus somebody else's. And depending on the exceptions and which ones apply and so on, the law in your case might be different than the law in someone else's case. So some common exceptions relate to things like, do you have a union, where you work versus not? Do you work for the government versus a private sector employer? What kind of industry do you work in? Like, do you work in manufacturing? Do you work in farming? The rules for all of that stuff could be different. So because of all of that potential variation, it is very difficult to quote a universal rule that applies to everybody. There are some universal rules that do apply to everybody, but there's a lot of variation potentially as well. So I say all of this stuff so that you know that this video that you're about to see, it is possible, depending on your situation, that you might not be able to follow it literally. So unfortunately, the only way to really know what applies in your case, like what rules, what laws, etc., is to go find a lawyer and kind of go over the specifics of your case with them. So hopefully that helped. Go ahead and share, subscribe, comment, all this stuff. But enjoy the video, and I will talk to you next time. Thanks. Hi everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over how California law treats meal breaks for hourly employees. Now, I'm hoping a lot of us can sort of work from our own personal experience here, or intuit from the term meal break. The basic idea is going to be that regardless of what it's called, lunch break, dinner break, whatever, it is a time period that your employer has to give you, the employee, so that you can basically stop working, step away from your job, and go eat something. And then, practically speaking, I'm hoping some of you have also, basically gone out to eat or, gone out to do a personal errand, basically left the employer's premises during your meal break. Generally, that's allowed. The flip side of that is that meal breaks generally are not paid. So, all of that said then, as much common sense and kind of practical experience, a lot of us have, I also find it very surprising that a lot of employers don't know about meal breaks. They don't know that they're supposed to give them at all. And then if they do give them, they don't know the correct frequency, the interval with which they're supposed to give them. The flip side of that equation is also true. So the thing is, I'm surprised by the number of employees, I guess, who don't know what their meal break rights are. And they don't know what meal breaks they're supposed to receive, like how much time they're supposed to receive. They don't know how frequently they're supposed to receive them. So I guess all of that said then, regardless of which side of that coin you're on, if you're an employee or an employer, hopefully this video should be equally helpful for you. So all of that said then, the governing statute that we're going to be working with today is California Labor Code Section 512. Which as always, I'm going to go ahead and write over here as well as paste and link in the description down below for you. So go ahead and take a look at that if that is of interest to you. So if you look at 512, then you basically can see that it breaks down like this. There is a general rule about the, the minimum frequency with which meal breaks have to be given. They can be given more frequently than the stated minimum, but the statute basically requires no less infrequently than what's stated. So that general rule then for the frequency, the meal breaks themselves can be waived under certain circumstances as well, depending on whether or not the criteria are satisfied. So I guess it's kind of a complicated way to explain it, but the basic idea then, the general rule, is you as the employer can give meal breaks however often you want. It's very common, for example, in some kind of occupations, to start work at 8 and have a lunch break at 12, for example, so 4 hours. That's common. You can do it that way. The minimums specified in the statute is your employer can make you, the employee, work for at most 5 hours, before you as the employee are entitled to a meal break of at least 30 minutes. So that's what I mean, like, the employer can, shrink that 5-hour time period, but they can't go beyond 5. So the rule of thumb, I guess the minimum rule of thumb to remember is at most 5 hours of work before at least 30 minutes of meal break. So that kind of general rule repeats as well. So the thing is, after 5 hours, you're entitled to 30 minutes. After the second 5 hours, let's say that you work a 11 or 12-hour shift. After the second 5 hours, at the 10th hour, you're entitled to another meal break as well. So assuming that none of the meal breaks are waived, and there are certain waiver conditions like this. So Labor Code Section 512 allows a meal break to be waived in 2 circumstances. Number 1 is if the employee works less than 6 hours per day, So less than 6 hours in a given day, normally they are entitled to at least 1 meal break. Can that meal break be waived? And the answer to that question is yes, it can. By mutual agreement, depending on I guess the industry, the work environment, it might be beneficial to waive that meal break, and the employee and the employer can mutually agree to do that. It is not required in the statute, but general good practice, I think. If there is a waiver, get it in writing, get it signed by the employer and the employee, and the employer and the employee should both keep a copy of it. Again, that's just general good practice. So the first kind of waiver situation to summarize then is less than 6 hours, that first meal or that meal break can be waived by mutual agreement. The second waiver situation is a little more complicated to explain. If the employee works at least 10 hours but less than 12, under the general rule, they are entitled to at least 2 meal breaks, right? So 30 minutes after the first 5 hours at least, and then another 30 minutes after the second 5 hours. Can they waive the second 30-minute meal break by mutual agreement? And the answer to that question is, again, yes, it is possible to waive that second 30-minute meal break, between the employer and the employee, again, by mutual agreement. In writing, signed by both parties, both parties keep a copy. The requirement, however, is that if you waive the second 30-minute meal break, you cannot waive the first one. So you basically, if you're an employee, you can't be forced to work for 10 or 11 hours, 12 hours, whatever it is, without at least 1 meal break. You cannot waive out of both, I guess, is the bottom line. So hopefully that was not terribly confusing, I guess, for any of you. Go ahead and watch this video again. To summarize then, there is a minimum frequency, I guess, for meal breaks, at most 5 hours before at least 30 minutes. The meal breaks can be waived. The first one is if you work less than 6 hours and you do it by mutual agreement. The second waiver situation is you work more than 10 hours, less than 12, you waive the second meal break by mutual agreement, but you cannot waive the first one. So hopefully all of that was not too confusing. Go ahead and watch this video again, leave a comment, share, subscribe, all that nice stuff, and I will talk to you guys next time. Thanks.